All right, so a little bit about myself. As I said, I'm president of the coalition, but I am an advocate for open government as a citizen, but I've also been on the other side of the table. I served as chief of staff to the Buffalo Common Council for 4 years. I was an attorney at the Buffalo Housing Authority, Erie County Department of Social Services. So in those positions, I would deal with open meeting law issues, freedom of information law issues. I would have to actually process FOIL requests at the Housing Authority. So I have experience on both sides of the table, which I think is helpful when dealing with these issues. As I said, our group is a nonprofit, nonpartisan organization. And whoops, I didn't want to do that, but here we are. So let's talk about the open meetings law. So this is the definition for the open meetings law. And the part in bold was recently added just in the past year. But basically, the open meetings law applies to public bodies. And public bodies are entities that consist of 2 or more members that perform a governmental function. So clearly, your village board, your town board, city council, county legislature, planning board, zoning board, school board, industrial development agency. There are many groups that are subject to the open meetings law. There are a lot that aren't, a lot of nonprofit groups. People kind of automatically assume, well, what do you mean you're getting a lot of public funding, even though you're a nonprofit? Not necessarily subject to the open meetings law. A lot of discussion and debate about committees. Committees in general that have advisory power only are not typically subject to the open meetings law, but there are exceptions. It really depends on who is serving on the committee. A committee that consists of all elected officials or government officials, that's subject to the open meetings law. There's been opinions that say basically if there's 2 or more elected officials or government officials, that makes a committee, even if it's advisory, subject to the open meetings law. So there's a lot of arguments, discussions, and debates about committees, and that's something we continue to deal with, something hopefully we can address in the law. Even things like, it's come up recently, charter revision commissions. Charter revision commissions have only advisory power, but they are subject to the open meetings law because charter revision commissions, their power comes from a state law, a state act, and there are opinions that makes them subject to the open meetings law. So just something to be aware of. In general, your typical government body with elected officials is subject to it. Committees gets a little bit of a grayer area. Next, you have to have notice for any public meeting or any body that's subject to the open meetings law. So for a meeting scheduled at least a week in advance, you have to give at least 72 hours notice. And that should be through a news release, putting it up on the website. Maybe there's a bulletin board at town hall. For a meeting scheduled less than a week in advance, sometimes public bodies will call, an emergency meeting or a quick meeting. Well, our favorite phrase, not really in the law, is to the extent practicable. Well, they have to give notice as best as they can. I think, this is certainly subject to great abuse. You see it sometimes. A press release goes out on Friday afternoon for a Monday morning meeting. Don't like that. Why are we doing that? Sometimes it's being done purposefully to hide things. It certainly makes people suspicious. If a meeting is going to be live streamed, public has to be made aware of where they can observe it on the internet, how it can be viewed. So what constitutes a meeting? This is another thing that comes up frequently. Sometimes public bodies will say, well, this isn't a meeting, it's a work session. Well, under the law, call it what you want. If there's a quorum of public officials present, it's a meeting. Well, it's a work session because we're not voting on anything, we're just discussing things. It's a meeting under the open meetings law. It needs to have public notice, public attendance. It doesn't matter whether you're voting or not. Just the fact that you as a quorum have gathered to meet to discuss public business, that makes it a meeting. Some call it, well, it's a pre-board meeting. Again, not really a meeting, subject to the open meetings law. Now, there are some terrible exceptions under the law, political caucus meetings where members of the same party can meet in private without any public notice. That's something that we're working to reform and address. We think that really guts the open meetings law and abuses it. So there are always exceptions to these rules. Meeting documents. We see this probably as one of the biggest abuses in the law. Meeting documents must be posted online at least 24 hours before a meeting occurs. Since 2011, there has been a requirement in the law to post meeting documents online. It astounds me that to this day, many years later, public bodies aren't doing it, claim to not know it's required. We strengthened this law in the past year or two, in that it's always been since 2011, you have to post online. The 24-hour requirement is new. There were some court cases that said, well, if you put it up an hour before the meeting, it's sufficient. There's really no requirement under the law otherwise. So we inserted this 24-hour requirement. This applies to all public bodies. Again, village board, town board, city council, planning board, school board, zoning board. Whatever documents are on your meeting agenda to be discussed should be posted online. And what I tell people to do is, whatever the board packet is, the packet of information that board members have in front of them, scan it and post it online. In my town in Amherst, New York, to their credit, they will scan and post 500 pages. A lot of places will post just a one-page agenda of meeting topics. That's insufficient under the law. Resolutions, contracts that you're approving, the public should be seeing that information. It's very hard to follow a meeting when you don't have access to the documents, and there's debate and discussion about the documents. So this is a significant part of the open meetings law. Every report we do, there seems to be a real lack of compliance with this. Meeting minutes or a recording must be posted online within 2 weeks of a meeting. This is relatively new as well. A lot of places post their meeting minutes, but until the past year or two, there was no requirement to post meeting minutes. Now there is. We don't like the fact that the law says meeting minutes or a recording. We take the position of, why can't you do both? I don't like scrolling through a meeting video to try to find what's of interest to me. I like written meeting minutes. It's just easier to scroll through and find out what happened. But if you have the benefit of doing both, even better. There seems to be this thought that, well, we can't post meeting minutes within 2 weeks because they haven't been approved yet. There's no requirement in the law to approve minutes. You can post them and stamp draft on them and then approve them at your following meeting. There's no requirement to approve minutes. It's an okay practice to do, but you don't have to. And something needs to be posted online within 2 weeks so the public can know what happened. Executive sessions, another area with a lot of issues. They should not be scheduled in advance. You'll see this a lot right on the meeting agenda. It'll say there will be an executive session, which raises the question, well, when was that discussed? And who decided we were going to have an executive session? I mean, that shouldn't happen. I understand it's kind of a courtesy to let people know, okay, that may be helpful, but you shouldn't schedule an executive session in advance. It should be an item that's on the agenda, and then a motion is made by someone to go into executive session. And that motion has to occur in public. There are a lot of mistakes made on executive sessions, and I think a lot of it's just bad habits. You join a board and you hear these motions that are made over and over, and you just think that's okay. That's the way it's always been done. But a motion stating to discuss litigation does not comply with the law. You should state the name of the legal case. Public has a right to know. Just saying litigation is not enough. And I think all too often, there is an executive session to discuss litigation when there doesn't need to be. If you as a board are just getting an update on the status of a legal matter, that can occur in public, and it should. There's no reason to do that behind closed doors. The only time to discuss litigation behind closed doors is if you're discussing legal strategy that you don't want the other side to know. But the truth is, board members shouldn't be involved in legal strategy. Leave that to the attorneys. So you have to say more than just litigation. Another one, executive session to discuss a personnel matter. Nowhere in the open meetings law is the word personnel even used. Insufficient under the law. You don't have to state the name, but let us know. Are you looking to discuss hiring someone for a position, disciplining someone? You can't just say personnel. And you also see to discuss collective bargaining negotiations or contract negotiations. If it's collective bargaining, you should state the name of the union. What union are you discussing? Contract negotiations, I don't know what that means. Does that mean, again, a collective bargaining agreement? Or is that some negotiation with a contract vendor that you're entering into, which really is, no reason to go into executive session for. So you have to be more specific when discussing these things. I see this a lot. In the statute, it says an executive session motion can be made for these things. So what a lot of places will do is they'll repeat this. And I've counted this in the past, but I forget what it is. But there's literally 17 different things in that motion. It could be a medical issue, a financial issue, promotion, demotion, discipline, suspension. I shouldn't have to guess, well, which one of these is the executive session motion for? So that is insufficient. There are cases, court decisions that say you can't just parrot what the statute says. See this a lot. Again, pick one or two of them. Be a little more specific than just throwing all of them out there. And basically, executive session should be rare and held for the right reasons. Just because you can hold an executive session doesn't mean that you have to. Believe it or not, you can discuss collective bargaining negotiations in public. You have the right to go in private, but you don't have to. You can discuss it in public. You can discuss a litigation issue in public. You have a right to do it in private, but you don't have to. So I think all too often there's a culture of secrecy in a lot of public bodies where some public bodies will meet longer in private than they do in public. And, that shouldn't happen. And I wish I saw more public officials objecting to an executive session. It happens, but pretty rarely. Well, why do we need an executive session? Why can't we discuss it in public? I wish more people would push back on that. So we have a new thing in the law about hybrid meetings. So you can now have a hybrid meeting if you're a public body where a majority of your members are present in person, but some participate remotely. We found during the pandemic that remote meetings were pretty good. A lot of people were going online watching their local government meetings, and we want to continue that. So if your board is interested in doing a hybrid meeting, you have to adopt a local law or a resolution. You have to put forth procedures, written procedures as to, well, when can someone participate remotely? In an emergency situation, an illness, out of town, whatever the case may be. You have to put something in writing which guides when members can participate remotely. If you're going to do a remote participation, you have to do it by video. If you're a board member, can't do it by audio only. And you have to allow, if you provide public comment at your meetings, you have to allow the public the ability to comment remotely as well as in person. Your meeting minutes have to reflect who participated remotely. So this is a new thing. More and more places are kind of adopting these rules. Just wanted to highlight that that's something that's been going on. And a recording of a remote meeting must be posted online within 5 business days. And you have to maintain those recordings for at least 5 years. So let's talk about freedom of information law stuff. Basically, all government records are presumed to be available to the public. We start with that presumption. If it's a record that a government official has, we assume that the public has a right to it. There are exceptions under the law as to things that can be withheld and not disclosed, but we start with that premise. And the freedom of information law applies again to pretty much public bodies, again, not necessarily to nonprofit organizations. And interestingly, the judiciary and the state legislature exempt themselves from the freedom of information law. You can still get some things regarding court cases and some things from the legislature, but a lot of things you can't. Those that make the rules carve out exemptions for themselves. Every government agency has to have a designated record access officer. And that should be, listed somewhere on your website or something to let the public know, well, who is the record access officer? Typically, it's the town clerk, the city clerk, for municipalities. But, it can be someone else, and, other government agencies don't have the town clerk or city clerk. Basically, the record access officer is the person responsible for processing FOIL requests. And there also has to be a designated appeals officer where you can appeal any denials of your request. It's oftentimes the town attorney, village attorney, city attorney, but that can vary as well. Under the Freedom of Information law, you can request a record. And there, that is defined, it's pretty broad, basically written documents, it can be videos, photos, maps, drawings, computer tapes. So it covers a lot of things that you can request under the Freedom of Information law. And there are certain timelines. So when you make your FOIL request, typically, you can do it by email, you can do it in person, it should be in writing. You can make a FOIL request verbally, although, I don't recommend it because, it's hard to follow up and document. So you should do it in writing. Some places will try to get you to fill out their specific form, and it's really much as how much you want to get into a fight about it. They really aren't supposed to require a specific form. Sometimes I push back on that. I send an email and they say, well, thank you for your email, but fill this form out. And I say, well, the form is just me repeating what I put in my email. Why do I have to do that? Sometimes it's just not worth the fight. Fill out the form. But they're not supposed to require a specific form. I typically do it by email. Within 5 business days, they're supposed to acknowledge your request. We see this a lot, that it's the delay, they don't acknowledge it within 5 days. And basically they have 20 days, business days from their acknowledgement to provide the information to you or put forth a deadline as to when they think they will have it. This, unfortunately, lately we've seen some horrific responses where they say, well, we'll get back to you in 6 months. That's not how the law is supposed to work. They're supposed to, have a reasonable deadline or date. A lot of times they don't even give you a date. They'll just say, we'll get back to you. After 30 days, if you haven't received their response or your information, you can file an appeal, which is just an administrative appeal. to that FOIL appeals officer saying, hey, it's been, 30 days. I haven't either gotten an acknowledgement, or I haven't been provided the information, or I haven't been provided a date to receive the information. Sometimes filing that appeal will prompt them to get going, not always. And they have 10 business days to respond to your appeal. So there are a bunch of things that are exempt from the Freedom of Information Law. I won't go through all these, but you can take a look at the statute. There's some pretty common ones that they will typically refer to, but they can't just typically blanketly deny your request. Your request is denied. They have to give you a reason. And sometimes, even if there are things in a document that they can withhold, that doesn't mean they withhold the entire document. They're supposed to go through it, black out sections that they believe need to be blacked out, although I've seen some ridiculous responses where I get 20 pages where every single word is blacked out. I mean, it's just hard to believe. You've all been dealing with this, I know, and I'm sure we'll get some interesting questions. But there are a bunch of exemptions under the law, which we can certainly get into more in the questions. So I'll just move forward. They can charge you for your FOIL requests. Typically it's 25 cents a page. What I typically do is there's no request for electronic documents. So in my FOIL request, I will say, please provide this information to me electronically, meaning that if they can scan something and email it to you, not doing an old-fashioned photocopy, they don't charge you the 25 cents a page. I've seen some places where they try to charge you for the time that they spend in processing your request and for copying pages. It's supposed to be one or the other. They can't charge you 25 cents a page and charge you fees for staff time in getting the information. It's one or the other, and they can only charge you for staff time if it's going to take more than 2 hours to get the information. I haven't seen it a lot, but it does happen sometimes. And I usually put in my FOIL request, if it's going to cost more than 20 bucks, let me know. Don't go make all these copies and then send me a bill for 500 bucks, which I have had happen. Don't waste your time and my time. I'm not paying 500 bucks. Don't make $500 worth of copies. So I put a kind of a limit in my FOIL request saying, if it's going to be more than that, let me know and let's talk and maybe we can figure out some other way. Sometimes they'll send it to me on a CD and they can charge you for the cost of the CD. Now, CDs don't typically cost $20. I've seen some place that, well, we got to charge you $20 for the CD. Well, why is that? It doesn't cost $20 for the CD. So there are some issues with fees. Some best practices that I think local governments can follow, or town clerks, or things that you can advocate for as a citizen. I think it's helpful to have a notify me link on websites where people can sign up to get email notification of meetings. Some places have this, some places don't. Although the law requires you have to post documents at least 24 hours in advance, you can do more than that. Most board members get their meeting packet 2 or 3 or 4 days in advance. So it always baffles me as to why it can't be posted at the same time board members get their packet. 24 hours is woefully insufficient, but that is the law. A lot of places require people to sign up to speak. There's really nothing in the law that requires people to be a resident to speak at a meeting. There's nothing that requires people to identify themselves. So it's just not a practice that is necessary. I know a lot of town clerks like to have, I guess, documentation. Maybe it makes speaking a little more orderly, but you shouldn't demand that people give their name and full address. You can just have people, or some places will want to know what you're going to talk about. Well, why do I need to get into all that? Some places make you sign up, 24 hours, 40 hours in advance, which I think is ridiculous. Basically, public comment time. Someone wants to make a public comment, step up to the microphone. You know, you don't have to demand that they give their name and address. We talked about posting draft meeting minutes. A lot of places when people do give public comments, I noticed that they don't recognize it in any way. I mean, people take the time to come to a meeting, share some thoughts. The least you can do is put it in the meeting minutes. Again, you don't have to identify people by name, but a resident spoke about, you know, concerns about garbage pickup, you know, something. You should have information regarding the right to file a FOIL request posted in a visible place on your website. You know, give some people information on how to do it. Where does it go? As we said earlier, you don't have to require a particular form. Communicate regularly and timely regarding your FOIL requests. Some places aren't good at giving you information on how to file your appeal. A lot of places don't know, public bodies don't realize you're supposed to send a copy of all the appeal documents to the New York State Committee on Open Government. So the appeal request, your response should be sent to the Committee on Open Government. That's a requirement by the Open Meetings Law.